I thought I'd briefly talk about a topic that I'm commonly asked about by my clients, which are contravention applications in family law matters. Hi, my name is Kerry and I'm a senior associate here at Genuine Legal. Now, the unfortunate reality is that sometimes parties to a family law dispute will face a situation where, despite having the benefit of court orders, the other party to those orders aren't following the orders, or they're conducting themselves in a way that constitutes a breach of the orders. This is not to suggest that contraventions to orders are treated lightly by the court. In fact, it's quite the opposite. So if you find yourself in a situation where the other party's not following the orders, you may have to contemplate bringing contravention proceedings to the court, which involves filing a contravention application with the Federal Circuit and Family Court of Australia. And within that application, you will be alleging a breach of the orders, and you'll be seeking some relief from the court to rectify the alleged breaches or to remedy them. Now, prior to bringing such an application to the court, the party making that application must first make a genuine effort to resolve those matters through family dispute resolution with the respondent, though the usual exceptions to that requirement do apply. In any event, when a party brings a contravention application to the court, the application must specify what it is in fact the applicant wishes the court to do as a result of the application. Now, to determine a contravention application, the court may do a number of things. And the court's power to do so is quite wide-ranging, you could say. For example, some forms of relief that an applicant may ask from the court could include a variation or suspension of current orders, ordering the respondent to attend and complete a post-separation parenting program, in order for make-up time, bonds, compensation, fines, even ordering the respondent to be imprisoned. So if you find yourself in a situation where the other party has not complied with court orders, it's recommended that you seek independent legal advice from a lawyer who specializes in family law matters, so that you could receive tailored advice, which takes into account the particular circumstances of your matter. And you could receive some advice in relation to whether there's any merit or basis, or whether it's appropriate to bring a contravention application before the court. Noting that for a contravention application to be successful, an applicant must prove to the court that the respondent intentionally failed to comply with the order or made no reasonable attempt to comply with the order. Now, a contravention application may be successfully defended where the respondent can prove that he or she had a reasonable excuse for contravening the order within the meaning of Section 70 NAD of the Family Law Act, a topic of which I can speak about in another video. In the meantime, there are some useful resources that you can find on the Federal Circuit and Family Court of Australia website on contravention applications. But of course, feel free to reach out to our office directly if you require further advice or if you'd like to discuss this topic a bit further. I really do hope that this was useful. Otherwise, I hope you all have a great day. Thank you.